question used to be asked into next day. But now you find hampered because of the potential. Because certain things that come up, I feel you're not having adequately answered.
Please do answer them in your submission. No difficulty.
It requires addition.
No, addition, you will know. So we are making notes, so you can always make the addition in your oral arguments. You know, Mr. Dwivedi, I'll give you a concrete example. I'm in the process of sort of formulating a judgment. We are still, now it's almost done, on Hindu law as to whether a child born from a voidable marriage is entitled to a share in the ancestral property. So today, I mean, over the last few days, I've opened the file. We didn't have any such limit as we have now imposed here. 3 or 4 written submissions by each member of the bar, 3 or 4 compilations by each member of the bar. It's impossible to sit down to dictate a judgment because, you know, you have judgments of different genres in different submissions coming up, and it becomes impossible for the judges to write judgments. So today in the morning, I was telling my secretary, I said, we first need to now look at all the judgments, prepare a separate file, put them in chronological order. But even then, it doesn't help because you have marked what was being read out by the lawyer. So, you know, this is the real problem which we face.
There are 2 issues. Judicial precedents were never in such large volumes as it is available today. Go back 10 years even. Number 2, the concept of giving written synopsis was comparatively not there. Everything used to be argued. We used to take down notes and dictate. Now, the purpose of a submission or a synopsis, as I understand, is to facilitate in dictating the judgment. Instead of that, it becomes so much more cumbersome that we don't know who is saying what, where. These kind of pleadings of thousands of pages used to not be filed. So that's. There are many cases of this category. No. At rethinking, they are certain.
Mr. Dwivedi, my take on this has been, if the homework in the office is thoroughly done, normally this problem doesn't arise.
It can never be complete.
It is possible to do.
The judgment can never be complete. The judgment can never be complete. That thought process will continue from your side. You know that it will continue from our side.
My fear always as a judge is that in this process, I've missed out some very important point of judgment because it's all, you know, sort of placed in different silos. That's what is really worrying for us as judges. This about reading, trying and collating, can always do that. Can tell our law clerks to put all the judgments together in a chronological order. Danger is you feel that, oh my God, I might have just missed something because things come in, you know, driblets over a period of time. Supreme Court gives 30 minutes time and 1 hour's time. So we need to now just.
The US Supreme Court do it in 30 minutes. The most complicated case, they only hear you for 30 minutes, including time interventions of the court.
No, we are far more advanced technologically. Actually, trust me, we are almost at the high end of the curve in India.
Part of habit action.
Yes. So that we can just keep it on the dais, you know, as the hearing. That will be very useful. Naika Bhushan. Yes, like you want to refer to it. Again, refer to that, very useful. Oh, you have also put it in a plastic. Excellent. Yes, Dr. Lala.
No library talk this time, my lord. But start again, my lord. I appear for the JK People's Conference, my lord, in writ petition 1165 of 2019. A question that your lordship put to Mr. Sibal was, have you challenged the presidential proclamation of 19th December? We've challenged the suspension, my lord, and that is very important to our argument on Article 3. There is also another petition, my lord, Sohail Qureshi, 1068 of 2019, which actually challenges the proclamation.
2068, right?
1068.
Yes.
Now, my lords, I would begin by saying, as well from my Lord the Chief Justice, that this oral submission is in the nature of a dialogue, and a very important dialogue, which even the US Supreme Court doesn't have. They assume everything is read, and there's a bit of question and answer, and that's it. And it is because of the nature of the dialogue, we have to, on an ongoing basis, answer what fell from your lordships as well. I'll give your lordships an example. My Lord the Chief Justice made a reference to 249 and 252. Of course, they are of a different genre. But nevertheless, my Lord, that question is very, very important for us to build the diversity argument, and whether there is transformative constitutionalism, whether there is a basic structure, whether that's a lost cause or not. Then, my Lord, your lordships had asked questions about Article 3(1)(d) and whether Article 370 subclause 3 survives. Now, this is important because it's been used only twice. It was used in GO 44, my Lord, and now it has been used once again in GO 273. Now, if it doesn't survive, my Lord, how can it be used in this particular way? We have to answer that question for your lordships. In addition to that, my Lord, there seems to have been some confusion or misunderstanding on the status of merger agreements, my Lord. The question that fell from your lordships was that once the instrument of accession is over, sovereignty is complete. Our respectful submission, my Lord, on this, which I will elaborate. I've done it in a note, my Lord. Like Mr. Zafar, I'll hand over that note, my Lord, to your lordships. My Lord, 3.7, as far as the instrument of accession is concerned, it deals with external sovereignty. Kindly bear this in mind, it's very important. External sovereignty is lost. With a few exceptions here and there. But internal sovereignty is not lost. That is why in Premchand, they say the monarch was still an absolute monarch. Not called for him. So, what the purpose of the standstill agreement was, what system would you have in the meanwhile? The state of the Raja of J&K didn't sign a standstill. The records show there was some toing and froing, and eventually, which means he retained all his power. So, as far as internal sovereignty is concerned, the standstill was very important, because all the powers of the Maharajas and the coming states, my Lord, retain their internal sovereignty. Now come to the merger agreement. The merger agreement is important, my Lord, because it finally indicates the extent of internal sovereignty. If there was no standstill agreement, and if there was no merger agreement, my Lord, the Maharaja would be absolute, as Premnath Kaul says. So I take 370 to be, my Lord, a substitute, a constitutional substitute for a standstill and merger agreement, without which, my Lord, we are lost. And I'll explore that, my Lord, later when I come to 370. Your Lordship also will not put a question to Mr. Zafar Shah that on the 4th of August, what were the autonomies that you were going to lose? He promised you a list, my Lord. One answer to that is everything, but I will indicate what these autonomies meant and what was lost for Jammu and Kashmir, which comes back to Justice Kaul's question, are we flogging a dead horse? The answer is no, my Lord. It continues, and it has to continue to preserve, my Lord, the federation and the conditions under which the federation was created. So let me begin with what I began with the other day, my Lord, and that is that we have the greatest diversity in the world. Take many continents together, take many countries. This diversity is unparalleled. That is why, my Lord, Professor Ravinder Kumar, I asked him, I said, what should I say in my Colombo lecture? He said, say that the Constitution of India is a constitution for a civilization with many nations and many cultures. And this is what makes our Constitution more exciting than any other. On the question of diversity, I was taking your lordships to where's my other note? Just reading it. I've, my Lord, done a list which I'll give to your lordships, my Lord, but I was going to invite your lordship's attention to Article 3 first. Of Article 3, my Lord. But I'm going to read one important aspect of it, my Lord. And that is the proviso which says that before anything is done under Article 3, it is mandatory for the President to refer the bill to the legislature. Mandatory. It's a condition precedent before you invoke Article 3. Just as there are conditions in Article 370 which have to be fulfilled by condition precedents. Now on Article 3, my Lord, the proclamation of 19th December virtually created an amendment of Article 3 by taking the condition precedent out. Mr. Sibal read all that to you, but I want to refer your lordships, my Lord, to that particular part of the proclamation. My copy, somewhere here. Your lordships will find this, my Lord. Like Mr. Dwivedi, I have no problem with what your lordship is doing. We just have to learn and catch up, my Lord. This your lordships will find in volume 3 documents.
Page 92.
And the PDF, my Lord, I'll just give it to your lordships.
Page 92.
Page PDF 92. Now, my lords, I want to take your lordship straight away, and it's very important that we should.
Sanjay Miller. Page ultimately everything boils down to this. Of course, the constitution itself, and but so far as documents are concerned, in one page now we have. In case something is missed, you can tell Mr. Dr. Dhawan's instructing advocate. They'll just put it in and what do we call this? This plastic made up.
Not- Divine fire. Your Lordship will see that there is a condition precedent in Article 3. And this condition precedent, my Lord, was added to by CO 48, which I'll show to your Lordships in a moment, my Lord. Which further required the bill to be sent to the legislature of the state, but we're not concerned with that because it has to be sent to every single state. Now, my Lord, I take your Lordships to this notification C subclause 2. So much of the first proviso of Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that article, so that much of clause 2 of 151, which is about audits, my Lord, of the Constitution as relates to laying before the legislature of the state of the report submitted by the governor to the Comptroller Auditor General. You will see that the opening sentence is the following provisions are suspended. In other words, my Lord, a mandatory provision of Article 3, whether it applies to Kashmir or elsewhere, my Lord, is suspended. It's not a question of just laying before Parliament as a substitute. Article 3 and Article 370 does not tolerate substitutes. Now, my lord, what does this do? This is not, my lord, that can be done under a proclamation under 356. It is a constitutional amendment which is subversive of the Constitution itself. If this suspension fails, my lord, President's rule will fail. And its extension, my lord, in July will also fail. You have amended the Constitution, albeit to all states and certainly to Jammu and Kashmir. And this mandatory provision takes us to the core of the mandatory requirements, my lord, of Article 3. Because the entire JK or Reorganization Act emanates from Article 3 and Article 4. Take away this condition, my lord.
How do we deal with this Article 356(1)(c)?
Sorry, my lord.
Article 356(1)(c) says that if he may make a proclamation where a situation has arisen that the government cannot be carried on in accordance with the provisions of this constitution in any state, and then C.
Make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this Constitution relating to any body or authority.
So the President has a power to suspend certain provisions of the Constitution during the operation of a proclamation under 356.
The suspension in this case goes beyond supplement, my lord. It goes to actually taking out a mandatory provision. Of course, my lord, Article 4 says that any change that is made will be treated as not requiring an amendment. But leave that aside, my lord. How is 3 and 4 to operate after this? The presidential duty, my lord, has to be a little more careful. Because this was tailored way back in 19th December 2018 to start a process, my lord, of amending the Constitution for the purposes of which.
Normally when the legislature, here of course it's the Constitution, uses the expression means and includes. Here it's not means, but it says make and includes. When means and includes is used by the legislature, it's an indication of expanding the power. So when the Constitution says, it begins by saying make incidental or supplementary provisions,
Yes.
and then says including. So this including seems to be to widen the ambit of what was stated earlier. Namely, the earlier part says you will make incidental or supplemental provisions. But then it says including. So including would mean that what was otherwise not a supplemental or incidental provision is within the ambit of the presidential proclamation, isn't it? Because suppose the clause C read just up to proclamation and didn't have and including. It's not and including, it's including.
That's right.
Suppose it ended with the word proclamation.
The operation of any provision of the
So
Constitution.
if the last part of Article 356(1)(c) was not there, you could have challenged any amendment of the Constitution on the ground that you don't have the power to make an amendment of the Constitution in the guise of making an incidental or supplemental provision.
Lord, this is the basis of our challenge, my lord. In our petition, we have challenged only the suspension.
My question is this. Suppose the president in a proclamation suspends the operation of any provision of the constitution. Is that amenable to a challenge on the ground that it is not incidental or supplemental? Or are these words of widening the ambit of the first part of 356(1)(b) so as to be immune from such a challenge?
This, my lord, has remained within the limits of 356. That is, for the governor, you read the president. For the legislature, you read the legislature. But I've never seen a provision in any proclamation, my lord, throughout, my lord, these decades, which actually uses the supplemental and including. I've never seen it take away a mandatory provision of the Constitution. This is exceptional, my lord. Now you can read it together in one way, you can read it together in the other way. If you expand 356C, my lord, then you will say that the president has a carte blanche to amend any part of the Constitution as part of the supplementary provisions.
Can you, for example, say that there'll be no judiciary in the state?
That's right, my lord.
That's what you're
That may be covered by the proviso, but at any
right.
rate.
Oh, yes. The proviso
So,
says, of
Lord,
course.
supplementally, this 356C has to be read with the mandatory provisions which it cannot dilute.
But actually, the proviso, Dr. Dhawan, the proviso seems to indicate that if Parliament, if the Constitution wanted to exclude a particular power from the authority to suspend a provision of the Constitution, then that has been specifically defined. So the proviso says that you will not suspend anything pertaining to a high court, or you will not assume to yourself as the president any of the powers which are vested by the Constitution in a high court during the operation of a proclamation under Article 356. So where it wanted to introduce a restraint on the presidential power, it has done so in the form of the proviso.
Right.
Do we now say that, well, apart from the proviso, there may be certain other parts of the Constitution which the president cannot suspend?
No, that is,
Or would that be reading into Article 356 words which are not there?
Lord,
Just one. I think coupled with the words appears to the president to be necessary or desirable for giving effect to the objects of the proclamation.
yes,
So there has to be connect and a nexus with the object of enforcing the proclamation. That's a restriction.
it must relate to 356. In other words, whatever is required to materialize 356, it must be related to that. And therefore, my lord, these words, necessary or desirable, are not carte blanche powers of the president. Could he have, under these provisions, suspended Part 3? It has been done, my lord.
Part 3?
That fundamental rights, directive principles. Could he have done all that, my lord? Therefore, my lord, it has to be given, even with the caveat of regards the High Court, it has to be given a limited meaning where your lordship finds that in every state that has been created under Article 3 and 4, this has been treated as a mandatory provision. There is a caveat that your lordships have imposed on Article 3 and 4, that all that it requires is a reference to the legislature, and the union is not bound by it. Those, my lord, when I come to my written submissions, I'll run through them very fast because I don't need to, my lord, take out the books or refer to the cases. This, to my mind, my lord, taints the entire process Gopal Shankar Narayan, my lord, on the inclusion provisions for suspending in whole or in part the operation of any provisions of this Constitution relating to any body or authority of the state. And then a colon. This further subscribes the extent of the presidential proclamation. Otherwise, my lord, 356 is an exception. It overrides federalism. It collapses democracy in a state. Because if the presidential proclamation does something that is irreversible, and that is a test your lordship will use. And Justice Khanna is right, my lord, when he emphasizes necessary or desirable. In relation to body and authority, as I pointed out. If this proclamation is bad, then its extension, my lord, in July is also bad. Because that was a parliamentary extension for a further 6 months.
Yes.
My lord, Article 358 suspends Article 19 during the proclamation, not beyond. This is now, my lord, and your lordships will see that further when I present CO 272 and 273. They go well beyond the period. And the genesis of all this, my lord, is the presidential proclamation. Even assuming, my lord, it goes for 1 year, it takes away conditionalities which cannot be taken away. Later, my lord, I'm sorry. I'm a little loud. I'm not used to whispering into microphones, like my predecessors. Now, my lord, I'm going to place. No, classrooms are very soft. Classrooms are a wonderful exchange with students, unparalleled, just as this is an exchange between the bench and us, my lord. And it is the nature of this exchange, my lord, that we must honor, under limitations of time, of course, my lord. But we must, my lord, honor this exchange as the most important part of arguing in this court. Now, my lord, in Article 3, CO, just want to point out the CO number. Lord, your lordships will see that because your lordship raised the question, what did you lose on 4th August, after 4th August? The CO 48, the PDF is 485. PDF 13, my lord. Take it out there. Going to have nightmares about PDFs, my lord. Now, my lord, if your lordships were to come to page 10 of volume 3, 406, sorry, not external, and PDF 13.
1-3, same volume.
Same one.
1954.
This is the
1954.
54 order. My lord, in a sense, the 54 order and 370, my lord, represents the constitution as relates to Kashmir. They were brought in by the Constituent Assembly. Now, I'll just read out that particular portion, my lord, so that I complete the 3-4 argument before I go into the business of how elaborate our constitution is. At the bottom of that page, my lord, 406, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of the state. It puts in a conditionality, my lord, not just to circulate it, but a conditionality, my lord, emanating from the state itself. Now, whether all this can be wiped out by CO 272 and 273 is another matter. I'm going to make one further proposition, my lord, about President's rule. Lest I forget, I'll refer to it later, my lord, if I can. The further proposition, which is a wider proposition, is this: that during President's rule, Article 3 and 4 and 370 cannot be invoked.
Article?
Cannot be invoked.
Article 3 and 4.
3 and 4, my lord. Why? Because they have conditionalities, my lord. And the conditionality is specific to the legislature of the state, to the government of the state. And the legislature becomes parliament. The governor becomes the president. Therefore, the conditionalities that exist in 3 and 4 and Article 370, neither Parliament, my lord, nor the president can be substitutes for the conditionalities that exist in Article 3, 4, and 370. You don't go through that process.
Dr. Dhawan, it's such a broad proposition with regard to Article 3.4. Forget about 370 for the time being. May not be correct in terms of the language used of clause 3 to 356. Let's hope it never happens, but in a given case, it can happen. There can be disputes
My Lord,
between two
the-
states and which is impossible to resolve until unless the center steps in with regard to boundary or something like that.
if
So broad proposition, if you're making a broad
I'm-
proposition like that,
I'm
it's
responding,
very difficult. It's very difficult to
I'm
accept.
responding.
Because we can be varied situations which we may not be able to postulate as of today.
My Lord, I'm making about a proposition about process and substitution. Because 370, subclause 1, my Lord, has its discipline. Just as 3 and 4 has its
I
mandate
said,
discipline.
leave 370 for the time being, but a broad proposition that Article 3 and 4, the provisos can never be suspended in terms of Article 356.
My Lord, the Parliament cannot be, and I'll show the debate when Amit Shah introduced this, my Lord, in the Lok Sabha. Parliament cannot be a substitute for the legislature of the state. That's a very narrow proposition, my Lord. I've been prompted, my Lord, nicely. And when Mr. Sibal talked about the political uses and abuses of the Constitution, then Proclamation 19th December, my Lord, is an abuse of the Constitution, and it would be a further abuse of the Constitution if we substitute for legislature
Dhawan,
Parliament.
Dr. Dhawan, there's difference between existence of power and abuse of power or use of power.
Of course, my Lord.
So let's not confuse the two.
Sorry, my Lord.
There's a difference between existence of power or use of the power or abuse of the
No,
power.
my Lord.
So let's not.
There is a power, no doubt. Its exercise is equally fundamental. We can't wish away the exercise as being purely nominal in nature. Now, my Lord, when Maharashtra was broken, and the judgments are all there in my written submissions, I'll take your Lordship very fast through them. They said you have to refer whether you like it or not. Likewise, Punjab, my Lord. You have to refer the bill to the legislature of the state. You can't self-refer it to Parliament. And the Constitution says no bill can be introduced, my Lord. It's a complete bar, my Lord, because we have to understand the limitations of President's rule. And this is one of the important, my Lord, limitations, that during President's rule, you may have the power to do whatever you want in 3, 4, and 370. But the process, my Lord, are conditions which can't be substituted by simply saying the governor will now become the president and the legislature will become Parliament. This process of substitution, my Lord, is subversive of the Constitution.
Dr. Dhawan, can Parliament enact a law during the subsistence of a proclamation under Article 356 in exercise of the power under Article 246(2) or in respect of a state list item?
Look, they can pass a law, my Lord. No doubt about that, subject to all the limitations that exist.
Right.
Except, my Lord, when it passes a law under Article 3 and 4, it must observe the conditionalities.
In other words, what you're your argument would be this, that while Parliament can exercise the lawmaking power of the state legislature during the subsistence
With all
of
its
the proclamation.
limitations.
Yes, with all
The
its
state
limitations.
list comes to them.
The state list comes to them. But certain other functions of the state legislature, namely in terms of the first proviso, to discuss a legislative proposal for altering the boundaries of the state, or under the second proviso for giving consent, that power can't be assumed by Parliament.
Lord,
Because then we are creating an exception to the language. I mean, you may possibly argue that you have to create that exception to give a purposive interpretation to that provision. But this one part is very clear that to accept your argument, we are then creating an exception to 356(1)(b). Because 356(1)(a) says that the powers of the state government are vested in the president or in the governor, as the proclamation would say, other than the powers of the legislature of the state. Then 356(1)(b) says, declare that the powers of the legislature of the state shall be exercisable by or under the authority of Parliament. So we will then, to accept your argument, we have to then hold, of course, maybe by a process of construction, that those powers which are referable to Article 3 and 4, which are powers of the legislature of the state, no doubt they are powers of the legislature of the
the
state.
difference between the legislative powers of the and the consultative and other powers of the legislature. If your lordship will see 357, my lord.
But it says, declare that the powers of the legislature of the state. Now, which are the powers of the legislature of the state?
Legislative powers. My lord.
No, not just the powers under Article 246, but it could be all the powers of the legislature of the state which are vested in the Constitution. Would that be not a more natural construction?
Take your lordships to Article 257, subclause 2. 357. (357)(1), my lord, declares that the powers of the legislature shall be exercisable by or under the authority of Parliament. It shall be competent for Parliament to confer on the President the power of the legislature of the state to make laws and to authorize the President to delegate, subject to such conditions as they may think fit, the power so conferred to any other authority. For Parliament or the President or any other authority in whom such power to make laws is vested under subclause A, to make laws conferring and imposing duties or authorizing the conferring of powers and the imposition of duties upon the union or the officers and authorities thereof. For the President to authorize, when the House of the People is not in session, expenditure from the consolidated fund of the state pending the sanction of such expenditure by Parliament. More important, the Lord, is to any law made in the exercise of power of the legislature by Parliament or the President or other authority referred to in subclause so and so, which Parliament or the President or such authority would not, but for the issue of the proclamation of 356, have been competent to make after the proclamation has ceased to operate, continue in force until altered or repealed or amended by a competent legislature. Which is the competent legislature? So, my lord, even as regards the functions of Parliament, they are specified 56 is not plenary in nature. It's important to understand that. It is the bane of the Indian Constitution, my lord. It's introduced again and again and again. In fact, the Indian Law Institute, I was reading the 1935 debates, my lord, where Churchill interjects and says, create the situation in every single province. Now, my lord, 356 has been used and abused to a point where there must be some discipline to it. It is certainly not, my lord, a power to amend the Constitution. Let's leave it there. Not transferring executive and parliamentary functions, that is the power to legislate alone, is the core of 356 and 357. There are many provisions in the Constitution, I have a list here, my lord, where legislatures exercise many other kinds of powers as well, my lord. Powers of election, powers of negation, powers of consultation. So it has to be limited, my lord. Otherwise, my lord, what happened in the 5th August onwards, my lord, can happen to any other state during president's rule. And that is why the broad proposition.
Legislatures exercise other powers. You said consultation. Which were the other ones? I just missed that.
My lord, I have a list here. Article 3, for example, my lord.
So how do we conceptualize those other powers? Consultation, you said you used that some phrase which I just lost. You said legislatures exercise other powers.
There are legislative powers which emanate from.
That's 246.
Article 245, which says subject to the provisions of the Constitution. And it's important, my lord.
What are the other powers that you said? You said consultative.
Article 3 is a consultative power to express views. Article 54 is the right to vote in presidential elections. JK was not able to participate, my lord, in the last presidential election. Article 80 is to elect members to the Rajya Sabha. Article 169 is to pass a resolution for the creation of legislative councils in a state. Article 171, 243M, my lord. I'll come to those because I want to go into the question of the diversity of the Constitution.
243M.
Then, my lord, 243M. And of course, most important, my lord, list of them, I'll give it to your lordships, my lord. I think it's better. But the important part is it's limited to the legislative powers. It certainly cannot amend the Constitution, Lord. Or I'm going one step further, or deprive the Constitution of its mandatory processual requirements. It's an argument about process and power. And this, in my submission, my lord, paints, my lord, also the extension of president's rule.
That point you have made,
done by Parliament, which I've already indicated to your lordship. This is fundamental, my lord, to how this process of diluting 370 occurred and how Article 4, my lord, eventually got used with all these incidental provisions, which were limited to legislative powers and none other. Now, my lord, I wanted to get back to the point that I started with, my lord, about the diversity of the Indian Constitution. I'll quickly take your lordships through it, because your lordship is concerned with how this diversity can be preserved. Bodoland, my lord, is mentioned in the Constitution. Nagaland has, my lord, and others have autonomous councils, which, well, I'll take your lordships through them. Now, my lord, if this can be done under President's rule, anything can happen. What I've done, my lord, to save time, is I've prepared a list of the articles that take us to diversity. I'll quickly run through them in the Constitution itself. I know your lordship doesn't like paper being handed over, my lord. But we can put it on the website, my lord.
This is acceptable because these are only articles of the Constitution.
Quite right, quite right. My lord, it saves time. It saves time. That permission is permissible. Because when your lordships didn't permit Mr. Sibal to give supplementary submissions, I thought that's a harshness that might be imposed on handing anything over to the court. Now, my lord, come to Article 2, my lord. This is important, my lord. It's Parliament's power to admit to the Union new states on such terms and conditions as it thinks fit. This is very, very different, my lord, from the assimilation, my lord, of the princes, etc., into the Constitution. That is, you go through an instrument of accession, you go through standstill, you go through merger, which then determines what is really entered into. Of course, my lord, in Podial's case, the majority judgment of Justice Venkatachalaya takes into account the entire history of the negotiations and says that although the Constitution says one person, one vote, nevertheless we will permit reservations for Bhutias, Leptas in the south. In the context of that history, we will nevertheless permit it. And there were two dissents, my lord, by Chief Justice Sharma and Justice Agarwal. Now, Podial reminds us that these negotiations are important, even though it says as it thinks fit. 2A was removed, my lord, in the Constitution because Sikkim was given associated statehood first. Now, my lords, kindly come to 3, which I've dealt with, 3 and 4. Then, my lord, kindly come to a very interesting provision, my lord, when we were dealing with affirmative action. That's Article 35. Prepare a proper list. Identify to be more. Now, this is a very interesting provision, my lord, relating to Article 16(3). I'll just read it, my lord, because it's important. Notwithstanding anything in this Constitution, Parliament shall have, and the legislature of a state shall not have, power to make laws with respect to matters in Article 16(3), 32(3), 33, 34, or for prescribing punishment for those acts which are declared offences under this part. And Parliament shall, as soon after the Constitution, make laws prescribing punishment. Laws immediately. Now, here's a very interesting provision, my lord. In relation to affirmative action, the power of the legislature is taken away. To change this, my lord, would require an amendment to the Constitution. Two judgments have dealt with it, my lord, which have dealt with, my lord, Andhra Pradesh and Jharkhand, but we needn't go into that. Then, my lord, if your lordships will come to Article 164. All done. I pointed this out on the other day, my lord. These are safeguards, my lord, for the federal unity of India. As indeed was 370 for the federal unity of India. It is part of the basic structure of federalism in our Constitution. When I was formulating this argument, I was told their lordships might be averse to a basic structure argument, so don't make it too strongly. So I'll stay within my limits, saying these are limits that a Constitution has in relation to federalism. Now, 164, my lord. I've given your lordships a list. I'm going around the list where taking your lordships through the important provisions. Article 164. My lord, has a proviso. Provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha, there shall be a minister in charge of tribal welfare who may, in addition to be in charge of the welfare of scheduled castes and backward classes or any other work. My lord, this, if it is to be changed, requires a constitutional amendment. Can't be done under President's rule saying we will have this minister or that minister. Then, my lord, if I may take my lords, my lord, to 168. Which empowers the legislature, my lord, much in the same way, my lord, as the JK Constitution empowered the legislatures. Article 169, my lord. 168 and 169. This relates, my lord, to whether there should be two houses in parliament or not. Finally, bear in mind, Jammu and Kashmir had a legislative council under its constitution. I'm reading, my lord, 169(1). Notwithstanding anything in Article 168, Parliament may by law provide for the abolition of the Legislative Council of a state, having such a council, or for the creation of such a council in a state having no such council, if the Legislative Assembly of the state passes a resolution to that effect by a majority of the total membership of the Assembly and 2/3, my lord, of those present and voting. In our case, my lord, the Legislative Council is gone. Well, actually, the whole of the JK Constitution is impliedly gone. Where was the power to do away with that? But that's another question that I'll come to, my lord. Then, my lord, kindly come to Article 239. I'd earlier said, my lord, the other day, that most of the union territories, other than Chandigarh, were created by constitutional amendment, or under the aegis of a constitutional amendment like the Sixth Amendment. (239A), my lord, deals with how union territories are to be created and the creation of local legislatures. This can't be given the go-by, my lord. Parliament may by law create for the union territory of Puducherry a body elected partly or partly nominated, partly elected to function as a legislature and a council of ministers, or both with such constitution powers and functions in each case as may be specified. Now, my lord, compare with what has happened in the case of J&K. State has become union territory, my lord. 2 union territories, one without a legislature, one with. This was not within the remit of Article 3 and 4 as an incidental provision, my lord, where you lose your character as a state, and there are 2 union territories that have been created not by reference to Article 239A or 239AA. If you wanted an elaborate constitution put in place, as in the JK Reorganization Act, you should have done what is done with Delhi. The council disappeared. Now, my lord, your lordships are very familiar with the 2 Delhi judgments, my lord. I'm going to refer to passages of it because they deal with diversity. But when I read my written submissions, my lord, they'll be there. I won't have to ask your lordships to PDF. Now, my lord, come to Article 240. Power of the president to make regulations for certain union territories. Puducherry is mentioned, my lord, as E. Do we add JK, my lord, and Ladakh to it? Because if 240 is applied to JK, as it must be, my lord, it's a union territory now. Perhaps that has to be added by constitutional amendment. But, my lord, the president will make regulations for peace, progress, and good government of union territories. Is this applicable, my lord? If so, my lord, it undermines not just federalism, my lord, but democracy itself. Now, my lord, may I take your lordships to 243, particularly to 243M and 243ZC. But 243M says part of panchayat, so fundamental to three-tier federalism, shall not apply to certain areas. I'm just showing the diversity, my lord, that exists. Now, my lord, if your lordships will come to subclause 2(3)(a), this will not apply to the district of Darjeeling of West Bengal, for which the Darjeeling Gorkha Council exists under any law for the time being in force. Even the panchayat amendments, my lord, have been curtailed in this balance of federalism. Not, my lord, by any executive exercise. And then, my lord, 3A, that it won't apply to Arunachal Pradesh. And then once again, my lord, here is a non-legislative function, my lord, in Article 4. Legislature of the state may by extend this part to the state except the areas referred to in clause 1. If the legislative assembly of that state passes a resolution to that effect by a majority of the total membership of the House and by a majority of not less than 2/3. Here is once again a provision, my lord, the most fundamental exercise of three-tier federalism, my lord, which is a part of our constitution. Then, my lord, ZC, 243 ZC, says the same thing, my lord, about the Delhi, Darjeeling Gorkha Hill Council. First, my lord, 243 ZB, my lord, which is about municipalities. It applies to union territories which have a legislative assembly. What happens to Ladakh? (243)ZC, my lord, has similar provisions as regards municipalities as it does to panchayats. In relation to the Darjeeling Gorkha Hill Council. (275), my lord, very fast. Sorry, 244, my lord. This is, my lord, dealing with scheduled and tribal areas. None of this can be wished away, certainly not by executive action. It is so crucial to understand this diversity of our constitution. 244 says, administration of scheduled areas and tribal areas shall apply to the administration and control of scheduled areas in any state other than the states of Assam, Meghalaya, Tripura, and Mizoram. And then 244A is a very important provision, my lord, because it relates to autonomous states. Our constitution, my lord, doesn't shy away from creating autonomous states, my lord. In fact, it reinforces them. And if there was that measure of autonomy, my lord, in JK, then it is not inconsistent with so many provisions in our constitution which respect autonomy for what it's worth in special areas. 244A, my lord, is very important. And when I come to Schedule 6, because if this can be done, my lord, under President's rule, place any under President's rule, expand it beyond the legislative function. Simply can't be done, my lord. These are mandatory provisions of the Constitution. 244A, formation of an autonomous state concerning tribal areas in Assam and the creation of local legislative councilmen. Parliament may by law, from within the state of Assam, an autonomous state comprising whether wholly in part of tribal areas. Autonomy, my lord, of the states is fundamental to our constitution. I rely on the two daily judgments, my lord, of your lordships, to reinforce this. Where your lordship respected, my lord, the autonomy of the legislatures and their existence. Those passages I'll show to your lordships very fast, my lord, because they're in my written submissions. Autonomy, my lord, is not alien to our constitution. You can't just standardize, my lord, all the provisions and say, look, we give autonomy here, but we're not going to give autonomy to J&K. Why? Because on 19th December, we took away a provision. J&K is not a dead horse, my lord, to be flogged or not to be flogged. It is the constitution of an autonomous region through the merger agreements which are part of 370. I'll come to 370 in a moment. It's very important to understand and not wish away the autonomy in Indian federalism. Then, my lord, if I may take your lordships, my lord, to 275. It has special provisions, my lord, made in 275, subclause 1A. I tell them you are my guru. Now, my lord, kindly see what happens to the disbursement of grants to autonomous states in 275 1A. Next, my lord, 279A, which is the GST amendment. I put it in summary form, my lord, in the table so that it will be a little easier for your lordships. Even in the distribution, my lord, as far as the GST applies, 279A subclause 4G says special provision, sorry. I'm sorry, my lord, where I put in my chart 279, it should say 279A, my lord. Now, my lord, 4G is a very interesting proposition. Special provision went to be made to the states of Arunachal, Assam, Jammu and Kashmir, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura, Himachal Pradesh, and Uttarakhand.
This must be on account of geographical reasons.
Sorry, my lord?
This must be on account of geographical reasons. All these are really states.
Partly that and partly because of the nature of the states. Your lordship is right, my lord. But this can be reversed and it will be placed before the GST because it lays later on that the GST Council will look at this. Now, my lord, I come to Article 330. very important provision, my lord. To say that special provisions can't be made in the Constitution is anathema, my lord. My lord, these special provisions relate to certain classes. Scheduled caste, scheduled tribe, Anglo-Indians, etc. Special provisions are a regular feature of our Constitution. I don't want to take your lordship through this, but these special provisions exist, without which, my lord, so much could not be done for the SC, ST or the OBCs. In fact, all these commissions, my lord, they report. And when the government of the state, it has a very interesting provision that it shall be laid before the legislature of the state, explaining with a memorandum the action taken or proposed to be taken on the recommendations relating to the state reasons for the non-acceptance. This is, my lord, 338(7). This is what should be done with President's rule, my lord. Even the governor's report, my lord, was not placed. This is what has to be written in, just as your lordship with Nagaraj added conditionalities, my lord. This is what should be written into 356. You put in all the information you have, you put in the governor's report, and you give the reasons for the non-acceptance. This runs for the other commissions as well. Otherwise, my lord, 356 has become a farce. When I was doing my book on President's rule, my lord, the elaborate discussion on Kerala, my lord, when President's rule was imposed. As we come down the line, there is hardly any discussion in Parliament. Why? Because all the information is not even there. And in the case, my lord, of Jammu and Kashmir, it wasn't there. The entire correspondence, my lord. I'm just building, my lord, something that is here in 338(7), which is also for the other commissions, my lord. Something, my lord, that gives information to the people and those people who have to, Parliament that has to bless or unbless, as the case may be, my lord, President's rule. That entire cache of information, which is so fundamental, my lord, to democracy and federalism, is missing in the proclamations. Then, my lord, if I may take my lords, my lord, to an interesting provision, my lord, 330, my lord, which makes special provision for reservation of scheduled castes and scheduled tribes. Sorry.
We saw 330. We've seen 330.
Assam is mentioned, you've done that. 343, my lord. This has to be read with the 8th schedule. Kashmiri, my lord, is one of the languages recognized by the 8th schedule. Kindly just bear this in mind. So in communications, in complaints, etc., Kashmiri can be used. That has not been taken away and cannot be taken away. Part of the spirit, my lord, of a region or a state is its language. Now, my lord, your lordships, when you look at the language of the Union, a commission is appointed. (347) makes special provisions for language spoken by a section of the population. And of course, my lord, chapter 4, that's 350, has special directives in relation to language. Who is going to make those special directives now? The President? Parliament? What is the status of Kashmiri now, my lord? Does it disappear from the 8th schedule, my lord? Then, my lord, 371A, my lord, has a very interesting provision. 368, my lord, I've kind of dealt with, my lord. So I won't take your lordships to that. But 371A, my lord. This is a very interesting provision, my lord. With all this discussion on the Uniform Civil Code, these are also unamendable provisions, my lord. Just as we are arguing that 370 was unamendable, my lord, by 368, subject to a certain procedure. (371A) says, notwithstanding anything in this constitution, no act of parliament in respect of the religious and social practices of the Nagas, Naga customary law and procedure, administration of civil and criminal justice involving decisions according to Naga customary law, shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. Non-legislative power. And the same is repeated, my lord. The important provision, my lord, 371, of course, concerns the hill areas of Manipur, very relevant. My learned friend has a point that if there is President's rule, the Legislative Assembly has this power. Can Parliament exercise it, my lord? That is why, my lord, it is restrained in 356. Now, my lord, the controversial provision in which your lordship has given a judgment is 371F, capital F, subclause F. This is Podial, my lord. If I have time, my lord, I'll take your lordship. So if not, my lord, I'll just refer to paragraphs. Parliament, for the purpose of protecting the rights and interests of different sections of the population of Sikkim, may make provisions for the number of seats in the Legislative Assembly of the state of Sikkim, which may be filled by candidates belonging to such sections for the delimitation of the Assembly constituencies, and from which candidates belonging to such sections alone may stand for election to the Legislative Assembly. This, my lord, was examined in Podial. I'll give your lordships a reference, my lord. Podial, which volume is it in? It's in volume 14, my lord. The argument was a very interesting argument. Baba Sahib Ambedkar itself said in Parliament that there will be one person, one vote, apart from the reservations from SC, ST, etc. So the argument that was advanced, my lord, which led to a 3-2 decision, was that although this is their part of the constitution, we have to take the history of Sikkim into account, and reservations for Bhutias, Lepchas, and the Sangh are permissible. This, your lordships, my lord, will find in volume 14, 6350. The majority starts at 6392, my lord. Mandatory provisions respecting, my lord, what the people of Sikkim had asked for. Albeit, my lord, with adjustments to the constitution. my lord, while you're on it, will your lordship just turn to Podial, my lord, because it's important to bear in mind. PDF क्या है? 305. Volume 14, 305. Starts it, sorry.
Volume 14, page
Cases volume.
30.
305. My lord, if your lordships will turn to 6394, my lord, which is PDF 349.
Where does it actually begin, the judgment? Ah, yes, I got it.
Sorry, my lord,
It begins at 305.
where it starts, my lord.
Yes.
And I'm referring to the discussion in Chief Justice Venkatachalaiya's judgment, my lord. PDF 349. I'm on 36394, which is PDF 249, 349. Now, my lord, here, I'll go through it very, very quickly. Just the learned Chief Justice, my lord, goes from para 66 onwards to all the proclamations and discussions till para 76, my lord. '74 in particular, my lord, at page 6396. The year 1973 saw the culmination of a series of successive political movements in Kashmir towards the government responsible to the people. Then it mentions the tripartite agreement, clause 5 of which is mentioned there in para 74. And various other provisions are made. 112 hectares. Where he actually deals with where he actually says, just give me a moment. Oh, they are. At para 120, Lord.
Of the judgment?
PDF 364. Why was this, my lord, promise to the people honored despite a provision of the Constitution? And this is explained by the majority at para 120-6409. PDF 364.
Para?
Para 120. What was the rationale, my lord, of respecting what the people of Sikkim wanted, despite the provision in this constitution, one person, one vote, and no vote on account of religion? The rationale and constitutionality of clause F and other provisions of the electoral laws impugned in these petitions are sought to be justified by the respondents on grounds that a perfect arithmetical equality or value of votes is not constitutionally mandated, imperative of democracy. And second, even if the impugned provisions make a departure from tolerance limits and the constitutional permissible limits, the discriminations arise are justiciable on the basis of the historical conditions peculiar to and characteristic of the evolution of Sikkim's political institutions. and the characteristic of the evolution of Sikkim's political institution. Therefore, my Lord, Your Lordship, as we've taken into the discussions that were held as far as J&K was concerned. And why it is important, my Lord, particularly as I indicated, the merger agreement, which deals with internal sovereignty. Unlike, my Lord, the instrument of accession, which deals with external sovereignty. Then, my Lord, the last 4 lines are important. What Article of 120, 371 FF, and the electoral laws in relation to Sikkim seek to provide, it is urged, is to maintain this balance in the peculiar historical setting of the development of Sikkim and its political institution. Sikkim is the only other Manod example we have other than Kashmir, where it was entered into Manod. And therefore you take into account all the antecedent discussions and see if they make out a case, whether for 370 or otherwise. My voice. Some whiskey in it. Now, my lords, I take your lordships, my lord, to Schedule 5. I'll skip, my lord, the in the Constitution. Schedule 5, my lord, deals with the administration of scheduled areas and scheduled tribes. Some of us are not happy with the Constitution Bench decision in Chebrulu, my lord, on how you apply legislative powers. But, my lord, there's a Tribals Advisory Council so when the governor, my lord, applies laws under 5 subclause 2, subclause 5 says no regulation under this paragraph unless the governor making the regulation, has, in the case where there is a Tribal Advisory Council, consulted such council.
Where's that, Dr. Dhawan?
My lord, this is in subpara 5, my lord.
Okay.
5.5, my lord.
Consultation with the Tribes Advisory Council.
Now here, my lord, even with there is power, you must consult the Tribal Advisory Council. Then, my lord, I come to the most important article on schedule on autonomy, Schedule 5, 6. Not my learned friend rightly points out that Schedule 5, my lord, deals with Assam, Meghalaya, Tripura, and Mizoram, excludes them, and then this, my lord, is applied in Schedule 6. Now, my lord, we come to the question of autonomy of the Northeast, my lord. My lord, without all these autonomies, my lord, India would have collapsed by now. Because unless all this was given, my lord, to the states in question in the light of antecedent discussions, my lord, this quest for uniformity across the board, which 272 and 273 seem to countenance, my lord, is not the heart and soul of the Indian Constitution. It is autonomy within federations, special provisions in relation to people. Take that away, my lord, we don't need such a big constitution. And all the antecedent discussions, my lord, become part of these autonomies and special provisions. We can't wish them away, my lord, and say they are just history. Okay. So far, so good. Now, my lord, kindly come to Schedule 6. Here is, my lord, apart from the ones that are dealt in Schedule 5, as my learned friend pointed out, this applies to tribal areas in Assam, Meghalaya, Tripura, and Mizoram. And subpara 1, my lord, is headed Autonomous Districts and Autonomous Regions. They have an in-between status between panchayats, my lord, and union territories. Now, my lord, under Article 1, Subclause 3, the governor, no doubt, my lord, with the advice of his Council of Ministers, wherever we read governor, my lord, it is rarely in his personal capacity. Apart from death penalty cases from which your lordships have ruled. The governor may, by public notification, include any area in any of the parts of the said table, exclude any area in any of the parts of the said table, create a new autonomous district, increase the area of any autonomous district, diminish the area of any autonomous district, unite two or more autonomous districts or parts thereof so as to form a autonomous district, alter the name of any autonomous district, define the boundaries of any autonomous district. This is a little akin, my lord, to Article 3. And this is where the entire politics of the Northeast, my lord, and the provisions, my lord, relating to the Northeast arise. Gorkhas say we want Gorkha land. Somebody says I want Bodo land. All this, my lord, emanates from Schedule 5, 6 and the concept of autonomy. Then, my lord, subpara 2, there shall be a district council for each autonomous district consisting of not so many members, of which 4 will be nominated by the governor. And then, my lord, there shall be a separate regional council for each area constituted an autonomous region under subpara 2. Subpara of each district and regional council shall be a body corporate with its seal, etc. What is important, my lord, is also what do these autonomous councils do? Kindly come to paragraph 3. powers of the district and regional councils to make laws. Has your lordship got it?
Schedule 6. Schedule 6.
To each of these is given a lawmaking power, with of course some limits, without which we might lose the Northeast. My lord. It is this democratization, my lord, of power that has enabled, my lord, us to make special concessions where they are necessary. Given the antecedent history, as I've explained in the case of Sikkim. Then, my lord, the regional councils, district councils and regional councils to make laws. And then, my lord, there are a series now, my lord, there are two interesting provisions, my lord, which your lordships will probably find in the footnote to the sixth schedule. That is an article, my lord, a subpara 3A. Wasn't without, my lord, protest and accommodation. Has your lordship got 3A, my lord, somewhere in the, probably in the footnote?
Yes.
Additional powers of North Kachar Hills Autonomous Council and Karbi Anglong Autonomous Council to make laws. And this includes, my lord, subject to the provisions, of course, of list 17 and 52. Interesting part, as my learned friend points out, in 371, 3AB, communication, my lord, is given to the, it says to the councils, that is to say roads, bridges, ferries, and other means of communication not specified in list 1 of schedule 7. Now, my lord, come to 3B. Your lordships are familiar, my lord, with the borderland, my lord, agitation. I needn't explore that further, although we have material on it. 3B says additional powers of the Borderland Territorial Council to make laws. And then lists on what they can make laws. Paragraph 4, my lord. I'm almost done, but not with this diversification point, my lord. Now come to paragraph 4, administration of justice in autonomous districts and autonomous regions. Which goes on to then say, may appoint suitable persons to be members of such village councils and presiding officers of such courts. It's a little lower down, my lord, in that paragraph.
So the bus हो गया है, कितना ही Which is the next clause?
No,
Para 4, you were saying.
I was taking your lordships to para 4, my lord.
That's the administration of justice.
That's the administration of justice. Of course, my lord, sub-para 3 says the High Court shall exercise jurisdiction over the suits and cases to which provisions of sub-para 2 of this paragraph
Yes.
apply, as the governor may for time to time specify. Even as regards the High Court.
Yes, Doctor.
Then, my lord, 121, sorry, para 12 and 12A. A and 12AA, my lord, I want to point out how in the state of Meghalaya and Tripura, my lord, autonomous districts have laws which are subject to what is equivalent to the 254 procedure. Your lordships will see in 12A, notwithstanding anything in the Constitution. Likewise, my lord, 12AA, notwithstanding anything in the Constitution. Then 12B from Mizoram, my lord, notwithstanding anything in this Constitution. It limits even the powers of the legislature.
Oh, yeah.
President's rule, where is on 370s.
Okay, we have.
Lord, the reason why I've cited all this, my lord, is because of the diversity this constitution, my lord, makes in federalism and democracy. A diversity that is to be treasured, not wished away in the name of uniformity. There are no dead horses to be flogged.
Diversity, I mean, you are right, it's possibly more diverse than the whole of Europe combined together.
Europe, America, Sub-Saharan Africa, take parts of the South Seas. This is, and so is Jammu and Kashmir, my lord, with its history. It has its own diversities. Diversity is necessitated because of the absence of the merger agreement, my lord. So what I'm going to call this, although, my lord, in my submission, I've called these asymmetrical provisions, these are in fact multi-symmetrical provisions. This makes our constitution unlike any other in the world. Simple examples of asymmetry are Canada. You will have French in one area and English in the other. Or Belgium, the three-language formula. Those are asymmetrical. The Indian constitution is multi-symmetrical. Of which J&K is a part. For its reasons, I'll now come, my lord, straight away to 370. Much of it has been argued, so I don't have to take your lordship through all of it, my lord.
Point after lunch that.
I'm sorry I've taken some time, my lord. Because as soon as your lordship asks for a list, as you asked Mr. Zafar Shah, your lordship said, you've done with point 6, now what's come to the other one? I have a list which I'll give to your lordship after lunch.
Dr. Dhawan, how long would you now take after lunch so that the next
An
person?
hour or so, if possible, my lord.
Could we cut it, possibly curtail it to about half an hour after lunch? Half an hour after lunch, can we conclude it? Maybe?
May not be enough now. Just give me that, my lord.
All right, 45 minutes. 2:45, we'll move on to the
My
next.
lord usually arrive late, my lord. That knocks off 10 minutes.
That's why I said 45 minutes. He didn't say 2:45. But we'll be here at 2 o'clock.
onwards, my lord, can happen to any other state during president's rule.
Dr.
that is
you
why
just,
the broad
mentioned
proposition.
Legislatures exercise other powers. You said consultation. Which were the other ones? I just missed that.
My lord, I have a list here. Article 3, for example, my lord.
So how do we conceptualize those other powers? Consultation, you said you used that some phrase which I just lost. You said legislatures exercise other
Look,
powers.
there are legislative powers which emanate from
That's 246.
Article 245, which says subject to the
245.
provisions of the Constitution. And
what
it's
is it-
important, my lord.
What are the other powers that you said? You
My
said
lord,
consultative. and
Article
what?
3 is a consultative power to express views. Article 54 is the right to vote in presidential elections. JK was not able to participate, my lord, in the last presidential election. Article 80 is to elect members to the Rajya Sabha. Article 169 is to pass a resolution for the creation of legislative councils in a state. Article 171, 243M, my lord. I'll come to those because I want to go into the question of the diversity of the Constitution.
243M.
Then, my lord, 243M. Then, of course, most important, my lord,
ये जो
list of them, I'll give it to your lordships, my lord. I think it's better. But the important part is it's limited to the legislative powers. It certainly cannot amend the Constitution, my lord. Or I'm going one step further, or deprive the Constitution of its mandatory processual requirements.